ACC Judgment 112 Champagne 17, 2023. Case on the freedom of speech for doctors to advertise for medical care. Head notes. The Taiwan Constitutional Court ruled that by allowing only medical institutions to advertise medical care services, Article 84 of the Medical Care Act, MCA, has unconstitutionally violated doctors' freedom of speech. Background notes. Article 84 of the Medical Care Act, MCA, stipulates that non-medical care institutions shall not make advertisement for medical care. This provision was introduced to protect people's health from harmful effects of inappropriate advertising. Medical institutions are allowed to advertise under the MCA, but the individual doctors are not, so that the regulatory authority may avoid facing supervisory challenges. Violators may be subject to a fine. The petition was originally filed by a judge at the Administrative Litigation Panel of the Taipei District Court, but the case was referred to another judge at the District Administrative Litigation Panel of the Taipei High Administrative Court after the reorganization of the administrative jurisdiction in 2023. The latter judge assumed the petition under Article 57 of the Rule of Constitutional Court. The petitioner was hearing a case in which the plaintiff, a doctor, has been fined $50,000 by the Department of Health of Taipei City Government for advertising medical care services. The petitioner believes that Article 84 of the MCA violates the freedom of speech, freedom of occupation, and equality under the Constitution. Summary of the judgment holding. Article 84 of the Medical Care Act stipulates that non-medical care institutions shall not make advertisements for medical care. Where doctors are prohibited from advertising medical services, this article contradicts the freedom of speech under Article 11 of the Constitution. Within this scope, this article shall lose its effect immediately from the date of this judgment. Reasoning. Scope of this judgment. Although people and entities other than a medical care institution are all probable to issue a medical care advertisement, this judgment only concerns the constitutionality where doctors are restricted from advertising medical care services under the challenged provision. 2. The case shall apply intermediate scrutiny. In addition to promoting medical services and attracting patients, medical care advertisement also concern the self-expression of doctors, public communication of medical messages, and the referral of medical information for patients to choose relevant services. As medical services are highly professional, correct messages offered by doctors are especially important for patients to make their choices. Even though commercial speeches are not deemed equivalent to other high-value speeches, and they may be subject to stricter regulation, they should be protected by the freedom of speech under Article 11 of the Constitution, so long as they are true, non-misleading, for legitimate transactions, and helpful for the consumer to make economically reasonable choices. The state may restrict commercial speeches by adopting regulatory means to ensure consumers access to true and complete information, avoid misleading content, promote other important public welfares. Regulatory means shall be substantially related to its goal. This level of scrutiny is supported by various constitutional interpretations, such as Taiwan interpretation number 414, 577, and 794. The disputed provision poses restriction on the subject of speech rather than on contents, which is different from the issues raised in previously mentioned constitutional interpretation. Nevertheless, the level of scrutiny therein is applicable in this case. Doctor-issued medical care advertisements concern the doctor's self-expression and the freedom of speech to convey messages to the public. It is also closely related to people's health. Legislators may adopt regulatory means that are substantially related to the protection of people's health. The disputed provision violates the freedom of speech under Article 11 of the Constitution. The disputed provision's legislative history and the ratio legis indicates two purposes. First, it is to avoid supervisory challenges for the regulatory authority. Second, it is to protect people's health from the harmful effect of inappropriate advertising. Under Article 23 of the Constitution, medical care advertisement by doctors concern doctors' freedom of speech and should not be restricted unless necessary for protecting people's health and furthering public interest. Managerial convenience for medical care advertisement cannot be deemed as a pursuit of important public interest. However, as the disputed provision also concerns protecting the health of the people, its purpose can still be seen as of important public interest and does not violate the Constitution. Prohibiting doctors from advertising medical care services does not necessarily help protect people's health. For more than 40 years in the past, from the promulgation of MCA in 1943 to amendment of MCA in 1986, doctors has been allowed to advertise medical care. No sufficient empirical evidence has been submitted by relevant authorities to support the argument that the doctor will make inappropriate advertisement once the restriction is lifted. Therefore, the means of prohibiting doctors from advertising medical care is not substantially related to its purpose. Another legislative reason is that since doctors should work in medical institutions approved by the competent health agency, they should be prohibited from advertising medical services. However, doctors may also work outside and at multiple medical institutions under certain conditions. One cannot prohibit doctors from advertising simply because medical institutions can already do so. Since doctors may conduct medical services independently based on their certified profession, their medical care advertisement cannot be replaced by that of a medical institution, and they should be protected independently by the freedom of speech under the Constitution. In conclusion, the means of the disputed provision is not substantially related to its goal, and the disputed provision violated the principle of proportionality under Article 23 of the Constitution, consequently infringing doctors' freedom of speech.